diverse perspectives to debate areas of agreement and disagreement about the constitutional issues in the news. It was the brainchild of the great Constitution Center team and our Atlantic colleagues, Yoni Appelbaum, who's the ideas editor for the Atlantic, and Rebecca Rosen, the superb editor of the Battle Site, who's just brought it to life and made it such a hit. So I'm going to begin by saying, Yoni and Rebecca, thank you so much for joining tonight.
Thank you for having me.
Great to be with you.
Yoni, I'll just ask you, you and I have talked about this Battle Site for several years, and we finally pulled it off, and you, Rebecca, have done such an amazing job. What have been your goals for the site, and how do you think it's succeeded?
Well, I think we wanted to model the kind of conversation that often happens among constitutional scholars, but bring that out into public view so that the public could really engage with the rich arguments that surround the Constitution and come to understand the sorts of principles that animate those conversations and grapple directly with the evidence that scholars use to back their claims and really to show the ways in which that conversation is nuanced and complicated in ways that sometimes align perfectly with our partisan predispositions or our ideological inclinations, and sometimes are sharply at variance with them.
That's been such a powerful lesson of the site, the fact that for so many of our writers, their policy and their constitutional conclusions diverge, and it's really been meaningful to share that on such a broad scale. Rebecca, congratulations and thank you for having just rocked it with the site. It's surpassed all of our expectations. What have you been trying to achieve? What have been some of your favorite pairings, and what are you hoping to see from the site in the future?
Well, for me, one of the most exciting things about running this site is that I'm just very fascinated by government. A lot of news organizations spend a lot of time covering politics, both in the electoral sense and also just between the parties in our institutions. And then also policy obviously gets a lot of coverage and great serious coverage, including at the Atlantic. But I feel that there's a little bit of a gap sometimes in our coverage of the institutions of government, how they relate to one another, how they respond to the needs of the public. And it's obviously such a rich moment to be engaging in those questions and that conversation. So for me, it's just been a labor of love to be able to commission essays and work with these amazing writers and scholars on the questions of American government and how it functions. Questions that I think we all really care about and really do need to be thinking about right now. So that's been my great joy. As for my favorites, you can't choose among your children.
Absolutely.
But I do find, for me, one of the lovely parts is the variety I get, not just ideologically, but also in terms of covering both news and kind of longer term questions that are evergreen. We've had moments like the impeachment of President Trump, or what's happened in recent months with the coronavirus, or the Black Lives Matter protests, where it's been really invigorating to commission pieces that are very responsive to the moment our country is in. But then, of course, there are these eternal questions that are more timeless. And those things overlap, but it's really nice to get to explore both those kind of axes of the questions of the American experiment.
And you've done such a great job in combining the historical and the current pieces. It's really added to the richness of the site. Well, you've just given me an assignment, and that's to write about Chief Justice Roberts and his role at the center of the court in wake of his recent decisions, including the one about abortion yesterday, and we had one on religious liberty today. So I started writing, but I guess I want to ask you, what questions would you like the piece to answer, and what questions do you have for me right now about Chief Justice Roberts and his role on the court?
Sure. Well, I don't know if these questions are particularly answerable, but I'm very interested in at least your instincts here. I think everyone's very fascinated by the chief right now and the role he's playing on the court, and whether his votes have been dictated by his most deeply held beliefs or some sort of strategic thinking that he's working on for what would strengthen the court as an institution, or play to the internal dynamics. So I just think the question of what is Roberts thinking in this moment, and what explains his recent votes?
Thanks so much. You can hear me take notes because, of course, friends, I have to answer these questions for Rebecca in the piece. And the question of, does he have deeply held beliefs, or is he molded by strategic thinking? I think I would say that he is doing exactly what he told me he would do in an interview for The Atlantic in 2006. It was one of the greatest breaks I've ever had as a journalist. He sat down to talk with me at the beginning of his first term as chief. He expressed great frustration that citizens were perceiving the court in ideological terms, 5 Republicans and 4 Democrats. And he said it would be his mission as chief to defend the court in institutional terms. And he said he hoped when people went back to his decisions, they would say that each of them showed a concern for the institutional legitimacy of the court that led citizens to think of judges as something more than politicians in robes. And he said he would try to achieve that by encouraging broad, unanimous decisions that were narrow, not broad decisions, but rather narrow ones that were not 5-4, but could be joined by people of different perspectives. And when he couldn't do that, he said he would put the institution first. And that's exactly what he did. He did that in the healthcare case, which explains his vote, which surprised many, but makes sense when you view it in those terms. It explains his remarkable interventions with President Trump, saying there are no Obama judges and no Trump judges. It explains his chastising of Senator Schumer for having called out Justices Gorsuch and Kavanaugh by name. It explains his conduct in the impeachment trial, where he was so strenuous in avoiding any substantive intervention whatsoever. But it was most striking, I guess, this term, both in that remarkable 6-3 LGBTQ rights decision, which is one that he would not have joined if he were not chief. Because after all, remember in the second Obamacare case, he took a purposive view of statutory interpretation and said we shouldn't just look at the text, but look more broadly at what Congress was trying to achieve. In that case, because it helped get Justice Gorsuch's vote, he was willing to be the 6th vote for a very literalist vision of textualism that he doesn't apply in other cases, because he thinks that he broadly agreed with the result, and he thinks the institutional legitimacy of the court is more important. And then there was the DACA case, the Dreamers case, where he did exactly what he did in the census case and said that fair procedures are more important than substantive results, and made the administration dot all the I's and cross the T's of the Administrative Procedure Act. And then there's the incredible abortion decision yesterday. And the big question is obviously, does this mean that he won't overturn Roe? And he gives a pay-in to precedent. It's a Burkean discussion of the importance of citizens having faith in the stability and predictability of the law, in not perceiving judges in partisan terms. He talks about reliance interests when people have structured their lives around a decision. But it's clearly central to him that the case is basically indistinguishable from the Hellerstedt case from 2016. If the exact same facts as Roe came squarely before him, certainly he wouldn't overturn. But this case also shows that he might do what he did, remember, with Citizens United, where he chipped away at the Buckley versus Vallejo, which allowed speech restrictions, leading Justice Scalia, the late justice, to accuse him of faux judicial restraint, and then finally pulled the trigger and overturned Citizens United. I think he would not squarely overturn Roe, but he might allow its narrowing in ways that might have the same effect. So this is not some kind of reprieve for the pro-choice movement entirely, but it does show that symbolically he's not going to be the justice who will formally overturn Roe, and that was hugely important. All right, I want to ask Yoni what he thinks, but what homework do you now have to me for me to answer for the rest of the piece before I turn it in later this week?
Well, I was just transcribing that, Jeff, as you were talking, and we'll
Okay.
post that in about 5 minutes. You know, the interesting thing about Justice Roberts and about the court in general is that we're in a system of checks and balances in which Congress has more or less stopped legislating. The executive, not just in this administration, but in several recent administrations, has pushed the boundaries of executive power, and the court is often asked to intervene, both to render effectively policy judgments and to pass judgment on those new assertions of executive power. It puts somebody like Justice Roberts in a position that he might not have sought for himself, but in many circumstances cannot avoid. And I think that all of us will look forward to reading your analysis of the ways in which he's navigating those extraordinarily treacherous shoals.
That's a very important observation that you've made powerfully in the Atlantic, and it's true at a time when the courts and Congress are essentially paralyzed and not legislating. It makes the court's job even trickier. Wonderful. Well, of course, I'd love to continue this conversation and get more good guidance from my editors and also hear their incredible insights. But we have such a great program ahead that I'm going to say with great gratitude, Yoni, Appelbaum, and Rebecca Rosen, thank you for launching the site, for running it so well, and for having assembled the great group of contributors that we're about to hear from now. Many thanks, and promise to get the piece on time.
Thank you, Jeff.
Much. Okay, talk soon. Great. All right, friends. Well, now it is my great pleasure and honor to welcome our first panel about policing and the Constitution. And we are extraordinarily fortunate to have three of America's greatest scholars and practitioners of policing. And I'll introduce them right now. Tracey Meares is Walton Hale Hamilton Professor and a founding director of the Justice Collaboratory at Yale Law School. I can just say that she's one of America's most nationally recognized and respected scholars of policing. And she was named as a member of President Obama's task force on 21st century policing, on which she served with great distinction. Charles H. Ramsey was appointed police commissioner of the Philadelphia Police Department in 2008. He served 8 years as commissioner and previously served as police commissioner in Washington, D.C., and is one of America's most respected officers. And among his many other distinctions, he served on President Obama's task force and also works with the National Constitution Center with our Policing and the Constitution program, which unites police officers to talk with school kids about constitutional values. And we're so honored to have him in that enterprise. And John Inazu is Sally D. Danforth Distinguished Professor of Law and Religion at Washington University in St. Louis. He is a contributor to the National Constitution Center's Interactive Constitution, where he wrote the Freedom and Assembly explainer. He's the author of Liberty's Refuge, The Forgotten Freedom of Assembly, out from Yale University Press, and a frequent contributor to the Battle of the Constitution website. Professor Meares, Chief Ramsey, and Professor Inazu, thank you all so much for joining.
Thanks for having us.
Thank you.
Let's jump right in. Tracey Meares, you have written so powerfully over the years that we need to answer the question of what is policing for, and you have taught us that policing is most effective when it is for legitimacy, trust building, and procedural fairness. Tell us more about that counsel and how it applies to our current vexation of the past few months.
Sure, Jeff, thanks so much. So as I'm sure you'll also hear from Chief Ramsey, the task force on which we sat, Chief Ramsey was actually co-chair of President Obama's task force with Lori Robinson. The first pillar of our report looked to the importance of establishing public trust and legitimacy as a key way of understanding the purpose of policing and how it should be carried out. We said a couple of things in that report in the first pillar. The first is that policing agencies and the members of those agencies who carry it out ought to think of themselves as guardians of the communities that they serve, rather than warriors. And so the idea that they would be warriors against crime and that anything that they do to reduce crime would be self-justifying is wrong. It's inconsistent with promoting trust and legitimacy. And another thing that we said that I think is relevant to the current moment is that in order to achieve these ideas of trust and legitimacy and procedural fairness, it's incredibly important for agencies to acknowledge their role in the past in wrongdoing and discrimination and what they're also doing currently. And I think one of the ways to understand what we're seeing in terms of demonstrations and uprisings is that people are forcing the issue publicly. I'm sure John is also going to be talking about that too, in terms of demonstrations and free speech, are forcing the issues of having this reckoning take place. And our attempt to refashion, turn around, or even transform policing as we know it. There's a lot to say about how to get to the there that people are talking about right now from here. But I think to start with those initial comments, I think is just where I'll start.
Well, that is a great place to start, and thank you for it. And Chief, maybe you can amplify and also tell us how to get there. It's an extraordinarily difficult time for policing and for America, given this fraught climate. How can we get to the place that you and Tracey have both identified, a place of trust and legitimacy and procedural fairness? And concretely, from the officer's perspective, how would you persuade officers and also citizens to help us get there in this current climate?
Well, first of all, thank you for inviting me tonight. I couldn't agree more with Tracey. How do we get there? That's an interesting question, and I'll answer it maybe in a little bit of a different way, not being a lawyer or a constitutional scholar or just a cop. So I want to look at it from a police officer's perspective, or at least a police chief's perspective. We've been talking about trust and legitimacy, and as Tracey mentioned, that was the very first pillar, and that was for a reason. Because without trust and legitimacy, nothing else really happens. I mean, you really can't get anything else accomplished if you don't have the trust of the people you serve. And if they don't see you as being legitimate, a person who really has not only the legal authority, but the moral authority to be able to tell them what to do. And I've given that some thought. I've participated in a lot of conversations recently, especially because of some of the horrific things that we've seen on television relating to police officers and use of force. And I hear police chiefs, and I've done this myself, use the term, vast majority of our officers are good. I do believe that. And it's just a few bad apples that are causing the problem. Well, apples fall from a tree. And if you have a lot of bad apples, you need to check the tree to make sure it's not diseased. You need to prune the tree so that in the future, you'll produce more good apples than you do bad apples. And I think that's what we have to do in policing, and stop making excuses. There are systemic issues that exist in our profession, and we'll never gain the trust and legitimacy in the eyes of people unless we acknowledge those problems, those issues, and really work toward correcting them. Is there racism in policing? Absolutely there is. But why wouldn't it be? It is. It's everywhere else in our society, and that's where we draw from. Doesn't mean that we can't take steps to try to fix it, but to try to deny that we don't have a problem with racism, with implicit bias, and things of this nature is, in my opinion, ridiculous. Power and authority. A lot of police officers do abuse their power and authority. But stop and think about it for a minute. We hire 20 and 21-year-olds. We give them a badge, we give them a gun, we put them in a real nice Crown Vic with lights and sirens, and then we wonder why we have problems. Out of 700 or 800 hours of training that a recruit gets in the police academy, how many hours are devoted toward dealing with the issue of how you handle power and authority that's just been given to you? The academies that I have been in, the answer is zero, absolutely none. And we need to talk about that, and not in the terms of what we've seen on these viral videos. It's the little stuff that, to me, prevents us from gaining the kind of trust and legitimacy we need. Parking in a no parking zone when you're not on a call for service, for an example. Running a red light. Why? Because you can, as opposed to actually going on a call. The same laws that we ticket and cite people for, we violate. And so if we do that, and we do it on, and people see that, it certainly it does erode the trust and the legitimacy that we all need. Truthfulness. we've had police officers that are on a Brady list, which means they can't testify in court. We have police officers, look at the Laquan McDonald shooting. It wasn't, I'm not talking about the shooting, the reports that officers submitted that were totally inconsistent with the video evidence that was there. I mean, you have to be able to, integrity means everything. Integrity is one of the core values that as police, we have to live by. And so when we talk about legitimacy and trust, you know, an 8-hour training in fair and impartial policing is not going to change that. Nor will a training in procedural justice change that. Your behavior changes. We have to change the way we think, the way we act. And we have to create a new culture where we're holding one another accountable in policing. We shouldn't need a video to tell us that something on the street was not appropriate, was wrong. The officers at the scene know it, and they need to be able to intervene, not just in the major cases, like in the George Floyd situation, but even that minor case where you're sitting in a car and your partner's driving and he blows the red light and you're sitting there and you say, why'd you do that? Well, you know, no, we don't violate the law. We enforce laws, we don't violate them. We don't violate the law. That's a duty to intervene as well. And so it's the small stuff as well as the big stuff. And when we change that, then we start to change culture. Then we start to change attitudes that people have toward us. I mean, there are obstacles in the way, unions and all that sort of thing, but there's a lot of things that we can do. And if we don't do it, someone's going to do it for us. It's either going to be through legislation or it's going to be the courts will decide for us. That should not happen. Police leaders need to step up and they need to do the things that they have to do. We need to have the tough, difficult, embarrassing conversations that we need to have to remove the veil and deal with these issues and deal with them and do it as fast as we possibly can and just change the way we were viewed in this country. I'm sorry to kind of go on and on about that, but I just think that if we don't do that first, then the other things will never really take root.
Wow, what a powerful statement of the need for departments to enforce self-accountability and to ensure that a culture of obedience to the law is pervasive, and it's very galvanizing. And thank you for sharing it. John Inazu, there's much to ask you, but you've written a bunch of really phenomenal pieces for the Battle for the Constitution site about the First Amendment right of assembly and petition. And I can't help sharing, if this isn't a bad technological experiment, your amazing essay for the interactive Constitution. So I'm going to try to do share screen right now. And friends, here we go. And I'm going to share. And look, if I haven't told you, friends who are watching, about the National Constitution Center's interactive Constitution, it will blow your mind. We're going to click on the First Amendment, we'll click on the Assembly and Petition Clause, and then here we have John Inazu and Bert Newborn, nominated by the Federalist Society and the American Constitution Society, with 1,000 words about what they agree the core assembly and petition right means, and then separate statements by John and Bert about what they disagree about. And multiply that by all 80 clauses of the Constitution. It is an astonishing learning resource that's gotten 30 million hits since it launched in 2015 and is just an endless source of learning. So John, in your essay, both your common statement and the separate statement, you say the Supreme Court really hasn't decided an assembly and petition case since the early 1980s and has relegated assembly cases to free speech doctrine, which has watered down the right. I'm going to stop sharing screen now so everyone can see you. But you also have argued in your Atlantic pieces that under well-established law, local authority and law enforcement can restrict assemblies that threaten imminent incitement to lawbreaking and violence. You say there's a good case to be made that tiki torch marches in Charlottesville, Virginia transgressed those bounds in 2019. This is a lot to throw at you, but everyone is, I'm sure, wondering, as I am, are there cases ever since the protests of George Floyd's murder began where the police response has violated constitutional grounds? And I'll just start by asking you about whether you think what happened in Lafayette Square was consistent with the First Amendment or not, and then you can expand out from there.
Well, first of all, thanks for having me, Jeff, and it's great to be with all of you. Easy answers to those questions. Yes, there have been cases, and no, Lafayette Square was not in any way in accordance with the First Amendment. Let me take a step back, though, and situate this and just try to explain why this is complicated. And I think there's both a constitutional and a criminal law dimension to this. So start with the constitutional dimension. You referred to the right of assembly and petition, which is how we've laid it out in the series of the National Constitution Center. But actually, and importantly, these are two distinct rights. There's the right of assembly and there's the right to petition the government. And about 120 years ago, the Supreme Court got that wrong and conflated the two into one right, assembly for purposes of petitioning the government. If that's right, then the assembly right is actually quite narrow. If you can only assemble to petition the government, there's not much assembling happen. It turns out the Supreme Court was wrong. A couple generations of scholars were wrong. Actually, the assembly right is more robust. It's not limited to petition. But in the meantime, Supreme Court doctrine introduced concepts including the right of association in 1958, and then really a free speech kind of framework to address protests and other gatherings in the 1970s. And the aggregate result of those doctrinal interventions means that the fullness of the right of assembly has really been forgotten in constitutional terms. So the protections of the group are relegated to this right of association, which does actually quite different work. And in the protest space, we resolve this fully under free speech doctrine. We talk about things like time, place, and manner restrictions and ample means of alternative communication. But when you reduce protest to just speech, you miss actually quite a bit of what's happening in the protest, all the other expressive dimensions. Protesters express through silence, they express through solidarity, they express through moving or not moving and all kinds of things. And when you just focus on speech, you miss all of that. And unfortunately, constitutionally, that's where we've gone. So that's one side of the equation that's really hard. And then the other side, on the criminal law side, is how protests are governed largely through laws against unlawful assembly. It makes sense that the corollary to assembly is unlawful assembly. The challenge with unlawful assembly is it's what's called an inchoate crime. It's a partially completed offense, like an attempt that points toward a target offense of usually riot in most jurisdictions. And so what law enforcement has to do on the ground is discern or figure out when a peaceful assembly inches toward something that's not peaceful or that's unlawful, that then inches toward a riot. That's incredibly hard to do, especially in very dynamic situations like protest situations. And yet law enforcement is tasked with the responsibility of knowing the jurisdiction-specific terms that comprise an unlawful assembly and having to know when an assembly moves from peaceful to unlawful and pointing toward a riot. And it turns out that in many parts of the country, we just don't have very good training on how to discern that at the local level, compounded further by the fact that local jurisdictions define these differently. So where I live in St. Louis, if protesters march from St. Louis City into the suburbs, as they do, they might encounter 3 or 4 different unlawful assembly restrictions with different requirements, different standards, different minimal numbers of people to violate the offense. And it's very difficult to figure out how a large group of people can comply with those all at once. So then let's finally turn to Lafayette Square, which as someone who writes on both the right of assembly, but also religion and other issues, the 40 minutes of Lafayette Square were just astounding to watch. Part of, I think, what we need to mention here is that protests are by their nature expressive, and the responses to protests are also expressive. So there's always something happening and signaling in the way that protesters engage and law enforcement responds to protesters. So in Lafayette Square, we had the President of the United States directing the disbanding of a peaceful protest with all kinds of law enforcement, including military assets. You had the chairman of the Joint Chiefs walking down the streets of Washington, and the expressive dimensions of that collectively, then tied to the forcible removal of priests at St. John's Church, the collective expressive experience of Lafayette Square was just stunning. And it has a lot of consequences expressively and substantively and symbolically. So I was, I mean, it's even still hard to process sort of what happened there. In some ways, it was fully in line with what the president has done from the claims about the size of the inauguration crowds to the desire to have a military parade a few years ago that didn't go anywhere, but the idea of a spectacle for the sake of the president that comes at the cost of other freedoms. But I think we saw all of that in Lafayette Square.
Fascinating. So much to unpack. And Rebecca, of course, is the assignment editor, but I would love to read your close legal analysis of the merits of the lawsuits against the police in Lafayette Square and how they might play out. Absolutely fascinating. Tracey, Meares, and first of all, friends, thank you for the great questions in the Q&A box. I see them, and I'm going to try to introduce as many of them as possible. And several of you have asked about defunding the police, including Kenneth Davis, who asks, how would you define it? And I'll add to that, Tracey, do you support it? How should we think about this claim, defund the police?
Yeah. So I'd say thanks for that question. I'm on record, as many law professors are who write publicly, as having written a piece in the Boston Review in 2017, so 3 years ago, in which I said, I'm quoting myself, policing as we know it must be abolished before it can be transformed. So take me literally. And I said it in 2017, and I believe it today. But let me tell you what that means for me. In that piece, I was talking about understanding policing as a public good. And it might seem strange that someone who sat on President Obama's task force, 21st Century Policing, who there are some folks today who would call that work reformers' reforms, disparagingly, not understanding that at the time we believed, and I still believe, we're at the forefront in how to make policing better. And that if every agency in the country had adopted our 59 recommendations, it would be much improved. That said, I still think that policing as we know it should be abolished because we don't center the public good of safety for everyone, and certainly the most fragile communities. We're going to have, after we speak, a panel of folks talking about COVID, and the same communities that experience high rates of violence are the same communities that are fragile and brittle with respect to their COVID response and have high rates of infant mortality and high rates of people experiencing homelessness and low rates of education and high rates of joblessness. I could go on, right? All of these things, the incidence and exposure to the criminal legal system are the same people and places that experience high rates of violence. And we have sent historically the same response to those places and expect that to produce a public good. So in the Boston Review piece, I explain what I think is necessary in order to really think about that. And we said this actually in the president's task force. Our two overarching recommendations were that the criminal justice system had to have a fundamental reexamination, which hasn't occurred since 1967 in the Johnson administration. And that was our first recommendation, 0.1. And our recommendation 0.2 was that there needed to be a serious consideration of how the institutions of criminal justice work with community organizations to achieve public safety. So if you think about that, that's my jumping off point for this conversation about defunding. That's what people are talking about, I think. They're talking about restriction, minimizing the footprint of very harsh criminal justice approaches that actually don't support safety. This gets back to the conversation that Chief Ramsey and I were talking about with respect to legitimacy and public trust, because we know that when you do promote those ideas, people are more likely to voluntarily comply with the law, and it's consistent with violence reduction, right? And then they're talking about, having less funds for that and investing in other strategies, institutions of the state and or private organizations that can do this work. I wrote a piece recently with Tom Tyler and Philip Atiba Goff in NBC Think, explaining 4 ways, and I'll just review them quickly, that one could think about defunding that are all not mutually exclusive. So the first I've already mentioned, you could take policing agencies as we know them and restrict the number of people who are armed, right? That's the idea of reducing the footprint of armed first responders. I think that's what many people are concerned about. So that's one thing you can do. You can have much more specialization of policing agents, of people who work on within agencies, you know, that is not mutually exclusive from the reduction of folks who are armed. You could have a lot more collaboration between policing agencies and community organizations, community-based organizations that do violence work. And we've seen this across the country, in Stockton, California, in Richmond, in New York City, the Life Camp with Erica Ford, Devon Bogan, Upswell, in Los Angeles. I could go on. You could have much more civilianization. The point is there are lots of options for thinking about how to take what we've got now and change its shape in a way that's much more consistent with what I think many people are looking for. And I think personally is consistent with what we called for 5 years ago. So I guess I just don't think that what I said in 2017 is fundamentally inconsistent with what we said in the president's task force. And I also think that all of that work is a part of the call that Tom and I were asking for in our Atlantic piece from last week.
Fascinating. Chief Ramsey, do you see things the same way? Do you think that calls to defund the police could be consistent with the approach that you and Tracey Meares took on President Obama's task force, or not? Do you understand the defund the police movement differently? What do you think of it? And we have several questions asking about concrete suggestions for how you think police should help police themselves. Mel Schuster says the police seem unable to police themselves and continue to commit unconscionable acts during unwarranted arrests. How does police culture change, and by what institutions? How long will it take? And I'll just throw in one final thing. You and I at the Constitution Center and our great team with Curry Sautner have this policing and the Constitution program. Might we work together with that program to help police officers embrace self-accountability? Chief, I think you're muted. Yeah, which is just what I did at the beginning too. So.
Yeah, well, you know, at my age, I'm lucky to be able to use this at all.
We all are.
Yeah. Defund the police means different things to different people. I've heard all kinds of things when it comes to defunding police. But what I hear probably more often is that people are looking at reallocating some resources currently given to police and then channel those resources elsewhere. Let's say community-based social services, for an example, for people that are responding to people in a mental health crisis or maybe substance abuse issues, things of that nature. I don't disagree with any of that, but I would just caution us and to really, you know, I've been in city government for a long time. And this is the time of year where, you know, cities traditionally just go through your budget trying to grab any money that hadn't been spent to fill holes in other areas, right? Now you've got COVID-19 and cities are really, really in bad shape financially. So grabbing money is now under this whole defund the police thing is part of it. Follow the money. If the money's being taken to channel into social services, make sure that's where it goes. Because the reason police have these responsibilities is because at 2 or 3 o'clock in the morning, there's no one else available. It's police. Social workers aren't out there. Substance abuse counselors aren't out there. And so they're going to have to staff up considerably to have people that are available 24 hours a day, 7 days a week to be able to respond. And even then, not every call you go to is going to be one where a social worker is going to be able to handle it, because some of these calls are a little dangerous. And so police could be in a secondary role, not in the primary role. So we need to just think about what we're saying when we say defund the police. Reality, police budgets for the most part, at least in the 3 cities I've worked in, anywhere from 90 to 96% of your budget is personnel costs. That's salaries, that's pension, that's healthcare, that's all that, there's not a whole lot left. And so you're not going to be able to significantly take money away without impacting your numbers and actually losing personnel. That may or may not be a bad thing. I'm just saying that people need to understand that that's what's called for. As far as police being able to police themselves, one of the recommendations in our task force report was for civilian oversight. There are different models out there. None of them are perfect. But I do believe there needs to be oversight for a couple of reasons. One, it is difficult to police yourself, quite frankly. And plus, people don't trust that we could do it. Even if we did it perfectly, people would not trust that we're actually, doing it in a very objective way. So having some oversight of police, I think, is essential. It's necessary. And I do think that many departments or cities are moving in that direction. And I think that's a good thing. I'm not one that likes to use terms like, abolish or defund or whatever. I think that there are ways in which we can talk about this without using extreme language, because that turns people off, it scares people. And we need to find solutions to these problems. And I think part of the problem we have in our society in general, in America right now, is you've got the extreme left and the extreme right, and those are the voices being heard. And, a lot of people are right there in the middle. And so we need to find ways we can come together to fix these problems. And I think it's a way of doing it. You don't have to throw the baby out with the bathwater, as they say. I think there's a way of doing it without compromising public safety. There's real crime going on. In 2020, to think you can disarm some police, in my opinion, is not realistic when this country averages 14 to 15,000 murders a year. Philly right now, they're rolling into July, close to 200 murders. New York is, there are cities across America that are up in violent crime. I would like to see that one day. It just ain't today. And so we need to think about how we transition. If we want to move in that direction, that's fine. I don't have a problem with that. But how do we get there? And we need to be very thoughtful. So at the same time, we're not jeopardizing public safety, but we are transforming the way in which public safety is delivered to people.
That is very powerful advice. And we are standing ready here at the NCC to host the discussions with you about how to create that civilian oversight in ways that will be effective in just the ways you've described. John Inazu, lots of questions, including from S. Miller, who asks, are you intending to justify lawlessness as protected under the First Amendment? Some in the press refuse to call rioting and looting as outside of the lawful bounds, and maybe take that question as an opportunity to tell us where the line should be drawn. You have a great piece where you argue that legislature should only apply unlawful assembly to inchoate actions that contemplate forceful and violent lawbreaking. With respect to nonviolent lawbreaking, law enforcement officials may sometimes need to wait until an act occurs or is clearly about to occur before they can intervene and arrest officers. And then I'll just ask for specifics. Are there any cases in the recent protests of the past month or so where police have legitimately responded with force against unlawful acts?
Yeah, sure. So, I think one of the complications here goes back to the nature of unlawful assembly provisions and how they aren't consistent across all states and jurisdictions. So some unlawful assembly provisions say that you must advocate for force or violence in order to be squelched. And others say if you advocate for any kind of law breaking, then you engage in an unlawful assembly. So that's a legislative matter. If you don't like the law, the legislature needs to change it. But in jurisdictions that say any advocacy of law breaking subjects you to an unlawful assembly charge, then if you say we're going to trespass or we're going to block the street, then you're subject to an unlawful assembly. In jurisdictions that say we're going to wait till the threat of force or violence, there's more breathing space. But I think that maybe the broader issue is whenever you get a lot of people together in an emotional context, in a dynamic protest space, there is going to be some kind of risk for instability. And law enforcement, I think, engages with that, usually with some awareness of that. And there are ways to do this, to allow that breathing space, to allow that risk before it gets out of control. Sometimes it means allowing for some non-violent law breaking, like some trespass, and sometimes these are coordinated with law enforcement in ways that are quite safe. But when that flips, and it can flip very quickly, especially at night when situations become extremely dynamic, and then law enforcement have to figure out how they protect themselves and how they protect others in the environment. And that becomes incredibly messy and incredibly complex. So have there been instances where law enforcement has legitimately used violence in protest situations where riots have broken out or violence has been occurring? Of course there have. That's happened in a number of these protest situations. Much harder is, how do you constrain and convey the nature of that violence and how do you minimize it? So think about a wide, broad protest space physically. And if there is an act of violence occurring in one part of a city block, if the police declare an unlawful assembly and say you have to disperse, how far does that order reach? Does it reach across all of the blocks, including the peaceful protesters over here? How long does that dispersal order last? Does it last for an hour until things are settled down, or does it go all night? And these are the kinds of things that, yes, there is a proper response to violence that should limit and constrain violence. Yes, law enforcement should be doing that, but the nature and scope of those restrictions have to be thought through. And I think often we collectively aren't giving enough guidance to those on the ground to make those decisions in as minimally a disruptive way as possible.
Thank you for all that. As always, you're reminding us it's complicated, but by carefully drawing these distinctions, we can think our way through it. Well, it's time for what are essentially closing statements in this completely fascinating panel. There's so many great questions in the Q&A box. I'll just note Lillian Brooks says, Tracey, loved the question of starting with what's the purpose of the police. This rings true to me as a former juvenile justice administrator. This has brought on a heightened result of the school to prison pipeline. Police are the disciplinarians in the schools and ultimately bring kids to the juvenile court system. Have you thought about this? And Jim Stewart amplifies on that. Police are called on two varied incidents that they can't be expected to handle. How would the needs of the public be best handled by various providers? You can answer as you please, but Tracey, I think I'll just broadly ask you, what do you want to leave our audience with? And what can you identify the most constructive area of reform in this extraordinarily vexatious and difficult time that you're involved with, or that you want to call our attention to?
Yeah, I think both of those questions call to mind something that Chief Ramsey had already mentioned, which is that police are available 24/7, 365 days of the year. And they are asked by municipal government leaders to be the catch-all, even in a context in which they're not adequately trained for it, and they know that they're not. You know, the current police chief of Chicago, who came from Texas, or I guess superintendent in Chicago, it's not chief, you know, has made a statement that I think I've seen on social media a lot, where he's like, you know, we're asked to do all these things. We don't really want to do all of these things. And yet, you know, we continue to do these things. And that's why I asked in the Atlantic piece with my colleagues, can we just talk about what police are for? Because police say that what they're for is public safety, but we know that there are a lot better ways to achieve public safety than simply sending armed first responders to all of these incidents. And we also know that the state, at least I do, needs to play a critical role in providing public safety. Because if we simply take policing as we know it from these most fragile communities, it's going to be a disaster. So we have to really think about what we're doing carefully as we get there from here. You asked me what I think is the most important thing to do. I always hate answering that question. Because I feel like you should do so many things all at once. So how about starting with the president's task force report? But here's one thing I think that people don't think about. And in a report that I did with, again, Philip Atiba-Goff, Tom Tyler, Elizabeth Hinton, who's a historian, and the executive director of the Justice Collaboratory, Carolyn Sarnoff, called Reimagining Public Safety, we pointed to one thing that policing agencies really need to do, and that's tell the truth. We really need to think about this historical approach to what policing has been, so we know where we're going. And I guess the last thing I'll say, Jeff, that I'll leave your listeners with is that if we do achieve true public safety and reimagining policing, I believe then we will actually fulfill the promise of Reconstruction. Thinking about a conversation that you and I had 4 or 5 years ago, I think almost today, actually, in at Aspen, which is, there are a bunch of people who have been denied, the true promise of citizenship, which is safety. And that is a legacy of of our inability to really achieve Reconstruction. So I really do hope we get it right this time.
Wow, it's so moving to hear you recall that conversation on the promise of Reconstruction at the Constitution Center. Behind the fake background behind me now is this amazing exhibit on the Civil War and Reconstruction, the battle for freedom and equality. And you've just reminded us that the promise of those Reconstruction amendments, that's what's at stake in this current debate, and we must work together to fulfill them. Chief, take it wherever you like. But I'm curious, among other things, about, as Tracey said, the President Obama's task force report is out there. Is that getting any traction in this extraordinarily complicated time? And what makes you optimistic about the debate? What's actually breaking through, and what for you are the promising areas of reform?
Well, believe it or not, the report is been resurrected to an extent because now departments are reaching out to try to find something that serves as a framework for change. And I think the report, even though it's almost 5 years old now, it's still relevant today. You asked about a couple things that could be done. One, Tracey touched on, and so have you, and that is helping police officers have a better understanding of history. And I think about the National Constitution Center and the program Policing in a More Perfect Union that myself, Carrie Sautner, and others put together as an idea of being able to expose police officers that, they weren't alive in the 60s, the 50s, even the 70s in some cases when you think about it. And so they don't understand the history of policing. And when I had my first visit to the National Constitution Center and learned about the educational program where you're tracing the history of America from the Declaration till today, and I thought, wouldn't it be interesting if we trace the history of policing during that same time frame? Now, granted, there weren't organized police forces back in the late 18th century. You had slave catchers, and you had other types of activities taking place that one could call some form of policing or law enforcement. But that aside, it would just be an interesting way of tracking the history of policing as America has evolved, so has policing. And when you look at policing, and for an example, the Civil Rights era, as the marchers on what's now known as Bloody Sunday came across the Pettus Bridge, who was waiting for them on the other side? Police. And so when you look at policing historically, it's very clear. Police have not always stood on the right side of justice, especially as we define justice today. Now, you may not have been alive during that period of time, but you need to understand that's the baggage as a profession that we carry in some communities and not in other communities. And I think that's important to understand, because you need to know why that tension is there. You need to know why the mistrust is there. And it's not just about what happened in the 60s. There's enough stuff happening today that's not right, that just adds to that. But history is a way of being able to put it in a context where I think we can educate officers. The one thing I think, if there's one area in policing, and we've got a lot of things that I think are very positive in terms of, service and courage and all those sort of things, but empathy. And I think what happens there, and it certainly has happened to me, it's hard not to become jaded over time. And you have to fight that so that you can still feel. I've often said, we'll be successful as police if we can teach police to see policing through the eyes of those being policed. We are all coming at it from different perspectives. And if we can see policing through the eyes of those being policed, then I think it goes a long way toward starting to kind of turn that ship. The other thing, which I think is important, and then I'll be quiet, It was our very first recommendation, which was an overarching recommendation, and that is to look at the entire criminal justice system. I know the focus right now is on policing, but I think it would be a mistake if we left it there. We need to look at the entire system. We need to look at those drivers of crime. What are those, housing, education, poverty, all those kinds of things that are drivers of crime. We have an opportunity here to do all that. Because it's not just about police, it's about prosecution, it's about courts, it's about corrections, it's about reentry, it's about the entire system. Fixing one part and not touching the other is problematic. It's not going to result in what people believe would be a favorable outcome in terms of looking at criminal justice. So I think those things are important. Police aren't the only ones that carry biases. I often think whenever I see that statue of Lady Justice with the scales and she's wearing a blindfold. Well, the reality is Lady Justice sees quite well, and even she has implicit bias when it comes to sentencing. And so we need to not, BS ourselves into thinking that it's just the police. The entire system needs to be looked at. We need to take serious action, but it needs to be done in a way where we're not compromising public safety. And John, one last thing, because I love what you were saying about the demonstrations and so forth. The last major demonstration I handled in Philly was during the Occupy movement. I mean, it was Occupy everywhere, right? Well, we had Occupy Philly too. It went on for about 3 months, maybe a little bit longer. Every single day, every single roll call, we started the roll call by having the sergeant read the First Amendment to the US Constitution to the officers who were assigned. These folks are protesters, but they're not your enemy. They have every right to be petitioning their government, to be doing whatever it is that they're doing, as long as it's lawful, obviously, not breaking windows and so forth. They're not your enemies. I'm sensitive to that because had it not been for the courage of protesters in the 1960s, I never would have had the opportunity to serve as police chief in Washington, D.C. or commissioner of Philadelphia. And so that's just reality. And we need to respect that right, because that constitutional right for protesters, that's your right too. And you need to understand that. Our job is to help them facilitate that, not get in the way of it. But at the same time, have that balance where folks that just want to go to the bank and cash a check ought to be able to do so without being impeded. And so that's the balance. That's the challenge for policing. But I think we can get it right.
Wow, what a moving, galvanizing closing statement, from the vision of reading the First Amendment to police officers to your call to see policing through the eye of those being policed, and your incredibly moving call for empathy. Thank you for all that, Chief, and looking forward to our continued work together. John, the last word is to you on this really memorable panel. So much to say, but I'll just add to the mix Margaret Clark's question. Have you considered the original Constitution was not wrong, and maybe because they lived through riots and protests, they understood the difference and risks back then, which is why it was written as it was, and whatever changes that were made in the 70s, as you discussed, should be retracted. Your final thoughts on the First Amendment.
Hopefully, my first book, The Forgotten Right of Assembly, argues for just that. So yes, I'm all for recovering the right of peaceable assembly as written in the text of the Constitution. I want to, in closing, I'd love to pick up on a couple of Chief Ramsey's points, because I think they point to a broader issue that all of us are probably thinking about right now. One is empathy, and the other is the necessity of working across the aisle, whatever the aisle is. And if you're just on social media, that aisle looks insurmountable. Those people are evil and you're morally right. And that's it, full stop. And that's just not going to work, right? I mean, maybe it works if you grab all the power and suppress the people you don't like, but that doesn't really seem like a very hopeful experiment going forward. And so I think we're left with the alternative of pursuing empathy and common ground. And in that common ground has to be the First Amendment. The First Amendment only works if it's a right for everybody. If it protects my speech and your speech, the speech I like, the speech I don't like, the protests I like, the protests I don't like. And I think it's an intuitive point, but it's a pretty accessible point. If you can, for everyone on this call, give me the political issue that you care about the most, and I can point you to somewhere in this country where a peaceful demonstration for that issue is being unlawfully suppressed in some way. That's a problem, and it's a problem that all of us should care about. And we should all care about speech and protest and expression. And so I think one tangible thing that we can do, well, two things. One, we need to, I think, dissipate some of the social media voices that pretend that there is no common ground here, because there is common ground and a lot of us feel it. But then second, we need to start cross-advocating. So I am most impressed when I see advocacy for First Amendment rights that protect somebody's group that they actually don't like or they disagree with. And that's been part of our country, and we need to see more of that going forward. I think when you get outside of the Twitter echo chambers, that's actually happening, and we just need to elevate that more. I think what you're doing, Jeff, the work that you're doing at the National Constitution Center, and the work that I think many of the rest of us are trying to do is toward that end. But it's a really important goal, because we're not going to see the kinds of changes that Tracey and Chief Ramsey are talking about if we don't actually find a way to work in greater numbers and across ideological barriers to get there.
Thank you so much, Tracey Meares, Chief Ramsey, and John Inazu, for a memorable panel and discussion of pleasing the Constitution and the First Amendment. It's been an honor to moderate it. I'm so grateful to you for joining, and really hope to continue this conversation in all ways possible. Thank you all.
Thank you.
Thank you so much.
Thanks. All right, friends, it's now my great pleasure to welcome our next panel, which is also an amazing group. And here they are. Adam White is Assistant Professor of Law at George Mason University's Antonin Scalia Law School, where he directs the law school's C. Boyden Gray Center for the Study of the Administrative State. Deborah Pearlstein is Professor of Law and co-director of the Florsheimmer Center for Constitutional Democracy at Cardozo Law School, and Polly Price is the Asa Grigg Candler Professor of Law and Professor of Global Health in the Rollins School of Public Health at Emory University. Adam, Deborah, and Polly, thank you so much for joining. We are going to jump right in, friends. I must say that we're very keen on staying on time at National Constitution Center panels. Like the Supreme Court, we like to end on time, but because we've given you such a, the panels have been so great, I'm going to run this till 8:15. So just for your plannings, I hope you will stay with us, but we must hear from these phenomenal panelists on the question of the Constitution and the coronavirus. Adam, let's start with you. There are so many cases currently pending in the lower courts about civil liberties and the coronavirus. They include cases involving religious liberty, and the Supreme Court just decided a non-corona religious liberty case today, but there are many involving the closing of churches and whether they should be entitled to exemptions. There are cases involving prisons and the treatment of prisoners. There are cases involving quarantines and the conditions under which the feds and the state can engage in them. I'll ask you about the religion cases to begin with, because I just want to start right in. Which ones are you following, and how would you describe the state of the debate about the free exercise clause and the coronavirus?
Thanks, Jeff, and thanks to the Constitution Center. I'd say that, as you mentioned, there's a wide variety of cases, and I think that all reflects the fact that at times like this, with the coronavirus outbreak, both state and federal governments see activated really extraordinary powers that are necessary to prevent or to contain the outbreak. And as we all know all too well, those powers, both at the federal and state level, maybe especially at the state level, have really impacted us on our day-to-day lives. And so it's natural to ask whether the burdens being imposed by the government are really justified as a matter of either the government's police power or the federal government its statutory powers, or also whether those infringe upon constitutional rights. The case you mentioned that was decided today, the non-coronavirus case, that was really a case of express discrimination against religion. At least that's how the court framed it in the Espinoza case, where in the state of Montana, there was a categorical ban against state funding going to religious schools, and the court held that that was unconstitutional when that state law was unconstitutional when it prevented a family from applying state funds in a scholarship to a religious school. Now that was a case of express, as the court saw it, express discrimination. What's happening in the coronavirus cases is a little more nebulous. The criticism generally is that it's not that laws are explicitly discriminating against religion, although there's always accusations like that. It's more that religion is facing disparate treatment that really isn't easily explained. And so people will point it to, say, prohibitions against gatherings, including gatherings of religious bodies, and say that, well, other people are allowed to meet. Why are you discriminating against us? Now, I know this all too well. Our church in Virginia, our Catholic parish, was shut down for a very long time, pursuant to the state of Virginia's requirements, and it's opening very slowly. So we know all too well how much this hurts. But the question is whether there's either express discrimination or unstated but intended discrimination. And if not, then the question is just sort of a balancing of government power against rights, as we've seen in RFRA and in other cases. Now, the Supreme Court recently turned away a couple of cases. One of them was called South Bay United Pentecostal Church, where the court decided not to hear the case. And Chief Justice Roberts issued an opinion saying that there wasn't express discrimination. And as he saw it, there really wasn't a clear case of state power unduly infringing upon constitutional right. Other justices, Justice Kavanaugh and others disagreed. But that's really the state of play right now. I'd say that as more things, and I'll end on this, I've gone a little long, but I'd say as more and more things open up, as states open more things up for business, I think we're going to see an acceleration of these cases to the extent that church communities find themselves left behind. But again, the judges in all these cases have to parse carefully between express discrimination, implicit discrimination, and just questions about burden.
Thank you very much for that. A great overview of the issues in the religious liberty cases, and we'll return to some of them. Deborah, I asked Adam to start with a concrete question involving religious liberty because there's so many cases. Maybe you can broaden us out a bit and give us a sense of the range of cases that you see the COVID crisis has introduced into the court system, both cases where the government is acting in a way that people claim infringes civil liberties, and some cases where the government is failing to act in ways that it might, that raise different legal issues.
Right. So thank you for this wonderful set of panels first, and for having me. I think your question is the right one. It's a great one, because when we think about state responses to emergency situations or serious public crises, I guess from a civil liberties point of view, I look for three kinds of concerns. One is the set of concerns, like Adam was just talking about as an example, right? Violations of particular rights by actions that the government is taking in order to address the emergency. So in the last panel, we were talking about infringements on rights of assembly under the First Amendment. Adam was just talking about concerns about the free exercise of religion. And there are other cases, a few other cases now ongoing about states that have imposed quarantines from people coming from outside their states, and whether or not that infringes on the right to travel that's been recognized by the Supreme Court. So there are always concerns about those particular rights, and we should talk about the details of them. I think one of the fascinating things about the government response to this particular crisis is that we haven't seen maybe as many of those as we might have expected, at least so far, in part because so much of the government's response, certainly at the federal level, has been characterized by inaction as opposed to sort of aggressive actions against individuals or individual rights. So I'm actually slightly less concerned at the moment about those kinds of infringements, although there are some concerns. A second kind I worry about are sort of what I would call opportunistic actions. That is, actions state or federal government are taking that are purportedly in response to the emergency, but in fact don't really have any rational basis in public health initiatives and so forth. And we've seen a fair number of those. So announcement just today by the administration that it's going to even further restrict and maybe simply remove, contrary to statutes and treaties, rights to seek asylum here in the United States, removals of environmental regulations on the grounds that for some reason the crisis demands them, bans, at least temporarily, on abortion altogether in about 8 states during the shutdown because those weren't medically necessary, or at least that was the state law. And we've seen a fair number of those what I would call opportunistic actions. And I think those are concerning. But we're seeing a fair bit of pushback in the courts, and we'll see, we can talk about in detail how some of those play out. But I guess I think for me, the most concerning category so far are the kinds of impositions on civil liberties or damage to democracy that you might see more systemically by the government's failure to act to protect rights that it has to protect or that is supposed to protect. So if you look at, for example, prison systems in the United States or immigration detention, and you have large numbers of people concentrated together in places where the risk of infection is enormously high, in order to protect those people, the government has a constitutional responsibility under the 8th Amendment to put in place new systems, whether it keeps people in custody or temporarily releases some of them, in order to address the threat to those individuals' rights and health and safety. A similar kind of example is elections, right? You think about rights to vote and the ability to carry out free and fair elections. In a situation like this, the government needs to provide money and additional resources in order to carry out free and fair elections. And if those things don't happen, then you have really profound threats to civil liberties and rights. And those worry me most, maybe not only because they tend to fall disproportionately heavily on minority communities that you see struggling with these rights as it is, but also because those are the sort of, particularly with elections and freedom of the press and so forth, kind of the gateway necessary conditions for having a functioning democracy. And when those are compromised, those are the ones that start to worry me most.
Thank you for that great series of distinctions between opportunistic actions and failure to act, and then those that latest category of the election cases as well. And I hope we'll return to several of them in the next round. Polly Price, you've written a series of really illuminating pieces on the history of the 1918 pandemic and what it can teach us. And in your piece, How a Fragmented Country Fights a Pandemic, you noted that back in 1918, when cities closed schools, churches, and places of entertainment, state and local judges routinely upheld the measures. There's so much to say about what the history of the response to that pandemic can teach us today. What would you like our audience to know about the lessons of 1918?
That we have been here before, but not in 100 years. And we have had in the past some very frightening pandemics, yellow fever in the late 19th century, which generated much of our federal law that we have today that governs the federal government's role in interstate quarantine. And then also, of course, the 1918 pandemic. And in many ways, we are back where we started. In 1918, the Surgeon General of the United States is sending out circulars to state health departments and putting ads in newspapers saying, please make your own mask and wear them. And then urging folks to please, wear a mask in public, and asking for state and local governments to have mask requirements. So the one difference that I see, and I agree completely with Deborah in the sense that the imbalance today seems to me that one cannot sue to ask the government to act to protect you in the same way that you can sue to challenge this based on some fundamental right to not wear a face mask, something like that. It's a very difficult question, but let's go back to 1918, a very different century in many ways, but most of the courts that dealt with challenges to what were local cities having face mask requirements, for example, but they also closed churches and schools and businesses, very much like today. Those challenges were generally upheld, but they were almost all of them in state court. So what is different today, a century later, it's much easier to bring federal constitutional challenges for reasons that we can talk about. But one thing that has not changed, and I think this is what's very significant about Chief Justice Roberts' recent action. We began the program talking about Chief Justice Roberts, and Adam mentioned this, but in South Bay United Pentecostal Church just a month ago, admittedly not a precedential decision in the sense that the Supreme Court is denying an interlocutory appeal for injunction. But Chief Justice Roberts went out of his way to affirm that Jacobson v. Massachusetts, this is a case from 100 years ago, more than 100 years ago, is still central to how the federal courts should deal with this. And if you don't mind, if I could just quote briefly from that. He says, "Our Constitution principally entrusts the safety and health of the people to the politically accountable offices of the states." And then he cites a case from more than a century ago. And then he goes on to say, when the officials undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially respected. So I, for one, think that there is room for a much greater federal role than we have. And when I look back to yellow fever epidemics, late 19th century, I look back to the Spanish flu, state and local governments are begging for federal help that they do not get. And in some ways, we are in a similar situation. Let me just throw out, and I'll stop talking, but let me just throw out a few where federal government leadership would help state governors, would help local mayors. One of those is OSHA, some workplace requirements that would help employers know what they have to do to avoid liability, to protect folks. The Federal Aviation Administration could make it clear whether face masks are required on planes or not. Procurement, we have governors who have gotten together in groups to buy PPE because they don't have federal access to it and they don't want to be on a market, singly and alone like a lot of our healthcare providers are. And then finally, travel, which was mentioned earlier. We've got many states, Hawaii, for example, but Florida, New York, which they say if people are coming in from outside, they should quarantine for 2 weeks. That's exactly what our federal government requires of returning US travelers to the United States. They at least suggest that it should be a 14-day quarantine. And so when there's no federal leadership on the interstate quarantine idea, you can understand why states would step in. They have undergone, many of them have undergone very painful closures, business closures, social distancing measures, stay-at-home orders, and they want to be able to control who comes in. And let's look at Hawaii as a nation. So many nations are, and the US now is being quarantined, by the European Union. You can't travel freely there. We do the same thing for many other countries, but Hawaii can't do that with respect to travelers coming in, either Hawaii citizens or not, or at least that was the position of the Department of Justice for their most recent order. I'll stop talking. Those are some of the issues that I see as greater federal role, but I'd like to leave with the notion that we have been here before. The problem is it's been more than 100 years since we faced these serious calamities. Our laws probably have not kept up. I think governors are probably doing the best they can under their state's emergency laws. Those are geared towards hurricanes and other kinds of disasters. And I expect that we'll see a lot more legislation coming out in the future about this. But the question is, who controls now?
Thank you for all that. Thank you for that really interesting series of suggestions about ways the federal government could act more vigorously. Adam White, I wonder if you agree. You wrote a really interesting piece for the Battle of the Constitution site, Deregulate for the Coronavirus Recovery, where you argue that White House offices like OIRA need to identify opportunities for relief from existing regulations. So imagine that Vice President Biden wins the election, the coronavirus is still raging, and some of Polly's suggestions are adopted. Do you believe they would be consistent with the Constitution, with federal law? And Mel Schuster asks in our Q&A box, would a more vigorous federal response be consistent with the 10th Amendment?
Well, it's true. I did say that now is a time where the government does need to focus in some respects on deregulation. And there I was focusing on deregulatory efforts, short-term things, not long-term things that might help juice the economy when it's time to open up. I do agree with Polly that there's a lot the federal government can and should do to clarify just federal protective requirements, especially in the context she mentioned, OSHA, the FAA, and a few others. One place where I'd slightly disagree with Polly, respectfully, and that this gets to the question that's being asked, is on this question of federal versus state power here. Now, I do agree the federal government hasn't done enough in terms of broad guidance, in terms of messaging, advice. I'm glad to see the federal government has put financial resources, behind some of its effort. But I think I would slightly disagree with Polly, maybe on the allocation of power, because I think it's good that the states take the lead. The century-old case that she mentioned, Jacobson, it was, after all, Jacobson versus Massachusetts, and the court, the laws at issue, which Chief Justice Roberts was referring to, were then the laws of the state of Massachusetts. I do think it's good that our states are responsible for taking a lead in many aspects of protection, including protection against communicable diseases, in part because the government response isn't strictly a technical matter, a matter of expertise. It has to be informed by that, and really that has to lead the way. But ultimately, there are really tough value judgments to be made about how fast to open certain things when you consider both the public health impacts and some of the impacts on people's lives and livelihoods, which in and of themselves can affect public health. And so I'm actually glad that the states take the lead regardless of the administration in terms of day-to-day management. And I don't know that, I hope I'm not overstating my disagreement with Polly there. It really is, I think, it's a matter of shades of gray. I do think it's important for the federal government, though, to play a leadership role on issues that are crossing state borders, and also just on bringing to bear the federal government's expertise, which is really unparalleled. And I don't think there's been enough of that, and that would have been a good thing for this administration to focus more on.
Many thanks for that. Deborah, there are several questions about liability with regard to COVID. Kenneth Davis asked, can someone discuss the issue of liability as it relates to COVID and people, businesses, institutions? How are the various interests balanced? And Ashley Meares says, I've seen some states contemplating the criminalization of spreading COVID. This reminds me of the criminalization of the spread of HIV/AIDS, which obviously disproportionately harmed LGBT people. I think this connects to the discussion earlier, but perhaps someone could comment on how we can move away from carceral solutions, because as Professor Pearlstein stated, COVID is only a more dire situation in prisons.
So those are both good questions, and they're sort of specific. Let me start with an overarching point and then address them each, because in the specifics, it's going to depend a lot on what the law is and what each state is doing. In general, right, the failure of the federal response, or the failure of kind of rapid responses, has a cost. And often the cost is, if you do nothing when you could do some modest things to stem the spread of a public health threat, right? Like early testing and early observation and early monitoring and so forth. And you wait until the disease is at crisis levels, now you're in a position where you may have to take more draconian steps, right? So instead of initial containment of the disease, where you can monitor people coming into the country, do widespread testing, and then identify who they are, track and trace, and then isolate those individuals. Instead, you saw widespread, nationwide, global shutdown, right? Because we sort of missed the opportunity for containment, and we're largely back at that point now, right? So instead of more limited, not great, but more limited infringements on civil liberties and rights, you have the government in a position where, in order to protect catastrophic damage to public health and, another 100,000 lives lost, they have to take more extreme steps. So I'm not surprised to see these sort of more extreme proposals out there, and states have, and historically have had, even though they haven't used it much, enormously broad powers, and they're called, constitutional police powers, by which I don't mean the power of the police agencies, right? But police powers, which is general governmental powers that the federal government lacks in order to address threats to public health and safety. So many states have the powers that they haven't yet used to impose detention conditions on people who are violating quarantine or otherwise not complying with state requirements. And that's a serious concern. So far, we haven't seen it materialize. And I hope, obviously, that won't be necessary and won't be the case. But here's a great example where modest federal intervention, by which I mean uniform messaging and raising public awareness of the importance of, say, wearing a mask, right? Wear a mask, save a lot of lives, and avoid the potentially catastrophic burden on civil liberties that these more draconian measures that states have in their toolbox may impose. The question about liability is potentially a really broad one, right? Because liability can arise in lots of different circumstances. Sometimes it's questions of contractual violations. More often it's questions of tort liability. But to address it, and those again vary a great deal by state, but just to take the potentially constitutional aspect of this question in two ways. So in the Eighth Amendment context, right, for people who are in prison having been convicted of a crime, the government or whoever the detainer is, whether it's the state government or the federal prison system, has an obligation under the Eighth Amendment not to engage in cruel and inhuman punishment. And historically, that has been, and today, that's interpreted to require the federal government to provide a certain baseline level of safe conditions of prison, safe detention conditions in prisons, right? And in the prison system for people who've been convicted, it's an Eighth Amendment theory. In immigration detention, it's typically addressed under the Due Process Clause of the Fifth Amendment. But either way, the standard is, can you show that there is, in one form or another, deliberate indifference to the health and safety of the people that you're detaining? So if you're a prison system and there's an outbreak of COVID in your facility and you do nothing at all to provide prisoners masks or socially distance or in other ways meet guidelines, public health and safety guidelines for addressing those conditions, in theory, you can be held liable. And there are, or you can be required to change, which is the more important thing to do, initially at least, address the circumstances through injunction. And we see actually a lot of litigation on that now. There are ACLU cases, there are cases all over the country, and in the lower courts, in the district courts, they found some success. The much harder questions, though, are yet to come. First, these have yet to see really much consideration by any federal appeals court, much less the Supreme Court. But what if prisons take some steps, right? Just simply not sufficient to stem the outbreak, which might require temporary release or home confinement or some other more extreme actions. There, it's very difficult to meet the constitutional standard of showing deliberate indifference. The prison system isn't entirely indifferent, they're just simply behaving inadequately. And whether existing constitutional doctrine on deliberate indifference in these circumstances is adequate, I think is a really big question and one we have yet to see play out.
Thank you for all that. Polly, Gary Moskowitz asked, what's the role of state and municipal governments? And just to play out your call for more vigorous state action more aggressively, is there anything the feds could do in a hypothetical future administration that would violate the Constitution? And tell us about the lesson of the yellow fever epidemics and what the Supreme Court's ambiguous statements about any limits on federal power to quarantine might be.
Well, I think there can clearly be instances in which the federal government overreaches. We haven't seen that because we haven't seen a lot of federal intervention. So I think for most everyday Americans, the question is whether has their state or local government overreached? And I think that it's a very complicated question because states, as you know, vary on the extent to which they have home rule, where Houston, for example, can have a face mask requirement if the state governor says no face mask requirements. So that varies so much by state that it's very hard to generalize, but it's interesting to see that the most recent activity on face masks, for example, is governors devolving authority to local jurisdictions to decide on face mask requirements. And, you know, that may be passing the buck. It may be empowering those jurisdictions, but nonetheless, it's very hard to talk in general about what authority does a mayor have versus a governor, because our 50 states mirror in their own states the federalism that we have at our other level. So we can't, it's very hard to generalize about that. So I guess what I'd say is I think Adam and I are on the same page about, I think that local governments, state governments, their health departments are on the ground. They know the conditions. They should be making the calls in some very basic considerations. Yes, it would be helpful to have federal assistance in the areas that I outlined. We don't have that. So let's talk about what the state government authority is. And the state government authority seems to be pretty substantial in the sense that most governors of the 50 states are relying on emergency declarations for these kinds of orders. And those emergency declarations have been in turn previously authorized by the legislatures. So in each state, it's still yet a question, has this emergency been met? And is this within the authority of the governor? At the end of the day, I go back to what Chief Ramsey said about trust and legitimacy, balance and challenge. And that is, you can't have a situation where you're trying to enforce a requirement on a population where the majority of the population rejects it. That's a useless waste of your law enforcement resources to go out and give tickets to people who aren't staying at home or aren't wearing masks and so forth. So it's really the messaging, and it's the, is there legitimacy and trust in that state and local government? And I do think, you know, the federal government backing them up in these tough decisions would be very helpful. It's also the case that, again, when you go to the situation where, you know, in what one state's rules are different from another state's, one county is different from another. I live in Atlanta. At one point, I was under a curfew and quarantine order in one county and not in the city of Atlanta. And yet I could walk a mile away and be under different rules. And that's just not helpful, or at least from a public health perspective. That's not helpful from whatever your political perspective might be.
Thank you so much for that. Well, friends, thank you so much for staying with us as we run over. I'm gonna, we'll have the briefest of closing statements just because we really don't want to impose on everyone's generous spending time with us much longer. But Adam, you know, in a sentence or two for each of you, what is the legal or constitutional violation that you're most concerned about that may arise in the COVID crisis, and what cases are you looking out for?
Well, what a question. I mean, so far I've been pretty comfortable with what's been happening. I think there's been a lot of infringements on liberty. Maybe some have gone a little overbroad, but not the kind of thing that courts could really intervene with. One thing I was worried about was the actions of Mayor de Blasio in New York, where he seemed to be singling out explicitly Jewish communities, and calling them out by name. I was profoundly troubled by that. And so I was worried about that. I'd say going forward, the greatest constitutional challenge, I just say in a sentence, is how we move from this emergency footing to a slightly more normal footing where, while we're trying to grapple with coronavirus, we're doing it through more normal channels of government with greater involvement by Congress and state legislatures. Our friend Yuval Levin and I wrote about this. I think pivoting back towards a more normal government footing that grapples with the severity of this problem is our greatest challenge.
Thank you for that. And we've put in the chat box your piece, The Flaw in the President's Newest Constitutional Argument on the Battle Site. Deborah, the same question to you in just a few sentences, the legal or constitutional violations that you're most concerned about moving forward.
I'm most worried about our ability to carry out free and fair elections. I think we've had more than enough warning shots across the bow as we've watched primary states really struggle, particularly Wisconsin, for example, Georgia, really struggle with the need to both conduct effective and timely mail-in absentee ballot and make those readily available to everyone. And at the same time, while they're having to shut down polling places, in order to protect public health and safety, make sure that everybody has a place to vote if they need to vote in person. I think there, the trade-off between competence and liberty is likely to be acute. We can do this, but it's one of those instances in which we have to have effective government from the federal level to provide funding to state and local election officials to get it done.
Thank you very much for that. We posted your piece, Zoom Congress is perfectly constitutional, as well as Polly's piece, How a Fragmented Country Fights in a Pandemic, and all these resources will be on our interactive constitution along with this video. Polly Price, the last word in this incredibly rich and unbelievably thought-provoking discussion is to you in a few sentences. What legal or constitutional violation are you most concerned about looking forward?
I couldn't agree more with Deborah and Adam, and thank you for having me on a panel with both of those. I would just leave you with not a constitutional challenge, but again, what Chief Justice Roberts said a month ago, which is when these officials, and he means state and local officials, when these officials undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. And to remind everyone, we are in an era in which there are medical and scientific uncertainties that have been unfolding as we go. We trust they will get better, that we'll have tests to be able to determine who is contagious and who is not, but we don't have them at the moment. And in an emergency like this, it does seem like, again, giving deference to the elected officials who have to take the heat for whatever decision they make is the right way to go.
Thank you so much for that. I was taking notes, and I will insert that with your permission in the Roberts piece, because I think it's very illuminating of his judicial philosophy. Thank you so much, first of all, to our amazing audience. You're still here, so many of you, at 8:15 at night, because you've taken the time out of your busy schedules to educate yourself about the Constitution, listening to complicated, difficult arguments offered by brilliant scholars of very different perspectives. This is a model of civil dialogue. I have learned so much from it. I know you have too. And I'm so, if you'll allow me to say it to our dear audience, proud of you for taking the time to educate yourself of the Constitution. Thank you for doing that. And please join me giving a great virtual round of applause to Adam White, Deborah Pearlstein, and Polly Price. Adam, Deborah, thank you all so much for joining. Everyone, we'll see you again soon. Have a good night, and thank you.
Thank you.
Bye, thanks.